Hello, folks. Todd Halleck here, talking to you today from my home office. Just got back from a physical therapy appointment. I had a little bit of knee surgery a couple of weeks ago, and got me thinking while I'm kind of in the medical system, uh, what about HIPAA privacy laws, and how does that impact your estate planning, or what should you be planning for? If you're not familiar with HIPAA by now, it's a law from back in the 1990s that protects healthcare, private healthcare information of individuals from disclosure to third parties by covered entities such as doctors or hospitals or physical therapists, places like that. But what if you need somebody to get your information? Or what if you need to get information, for example, your child who's now over 18? What can you do? Well, you can authorize individuals to be authorized recipients of your healthcare information, your private, otherwise private healthcare information. And that can be done through your healthcare directive, healthcare power of attorney. That could be done in a separate standalone HIPAA authorization, but it is authorizing a third party to be able to have access to those records and for those entities to disclose that information to those third parties and not be in violation of the HIPAA privacy laws. Our medical community takes these HIPAA laws very seriously. So if you've ever tried to get this information for a third party, you know it can be difficult. They won't talk to you. They can't disclose information. They make the person get on the line. So really important, because there may be a time, like I said, when you're trying to get information for a child, or you want someone to be able to get information for you because you're unconscious or whatever the case may be. You want to have that authorization in place. And so that's the way you do it. The other thing that's important to remember about HIPAA that people forget is that it doesn't just apply while you're alive, it's effective even after you die. So your information is still protected even once you've passed on. If you don't have an authorization that extends beyond your death, then that can trigger a probate, meaning going to court and having somebody appointed to be able to access that information. Had a client one time where they were a healthcare provider, and someone was wanting to get information for a deceased child. We just simply couldn't provide that information until we said, hey, you got to go do a probate, get appointed, then we can release that information. Hate to have to tell people that, but that's what the law is. So make sure that not only do you have an authorization in your healthcare directive or in your healthcare power of attorney or a separate document, but that also allows for that authorization to continue beyond your death for at least some period of years. So anyways, think about that as your next time you go to the doctor. What do you have in place so that if time comes and somebody needs to get access to your information, how easy is it going to be, or how difficult? Take care.